Hey everyone, Harry here to talk about a very important, I think, decision about the 14th Amendment challenge to Donald Trump's qualifications to be president, which ultimately goes for Trump and which he has called a, quote, total victory, but close quote, but not so fast. I think, in fact, it's much worse for him than he realizes. And in fact, the part that goes against him is far, far more important than the part that goes for him. All right, very brief, because you guys know this by now, but recitation of what we're talking about. Section 3 of the 14th Amendment, added after the Civil War, says that if someone has taken an oath as an officer of the United States to uphold the Constitution and thereafter engages in insurrection, that person is no longer eligible or qualified to be an officer of the United States. It's undisputed, even though courts haven't ruled at all on the provision, or ruled only, very sparingly, that this is a qualification under the Constitution, the same way that it's a qualification to be for president, over 35 years old, natural born, etc. This is a qualification. But what do you make of that qualification? And most importantly, how do you enforce it? So several courts have heard challenges brought by different voters in different states saying, hey, Donald Trump took an oath and then engaged in insurrection. He's not qualified to be on the ballot. Take him off the ballot. And every court to consider it so far has basically punted or deflected the issue, saying perhaps it's not ripe yet, or more to the point, this isn't for courts to decide. This is a political question. Congress has to be the one that says the provision has been violated and we need some act of Congress. There's been huge scholarly activity since it's been clear that Trump's conduct at least raises this issue, and some very important scholarship backed in the public sphere by some very heavy hitters like Professor Lawrence Tribe and former judge, very conservative judge, Michael Ludig, saying, nah, you don't need any special act of Congress. It's sitting out there right now. It's quote unquote self-executing. And the opinion in Colorado gave a huge shot in the arm to that point of view, because what Judge Wallace did was hold a week-long hearing, take evidence, hear from people about exactly what happened, exactly what Trump did, hear from experts about what is an insurrection in the, as it was meant in the 1860s, all kinds of things of that nature, and proceeded to write a 102-page opinion setting out the law and applying the facts, and goes through everything and finds that, makes credibility findings like Trump's witness Kash Patel, she finds not credible, and states a test for what it means. The two big terms are, did he engage, and was it an insurrection? On engage, she adopted basically what I think is going to be the test. It's a First Amendment test. It is what he did covered by the First Amendment, so it wouldn't really count. In other words, did he have the intent to incite imminent lawless action? If so, under well-established First Amendment doctrine, there's no First Amendment defense to it. And Wallace goes through it all, makes findings about Trump's intent and the like, and says he so intended. And then insurrection, she accepts the expert view that this is what it meant back then. I should read it to you because it might matter. Any public use of force or threat of force by a group of people to hinder or prevent the execution of law. She says that's the test, and that's exactly what he was trying to do. So boom, in a long, 95 of 100 pages, a very detailed evidence-based finding that Trump engaged in insurrection. Now, then it's true. She then kind of blinks, if you will, and says, however, I'm not going to disqualify Trump from the ballot because there's another issue out there, and it hasn't been decided. We really need clear and convincing evidence. If you read her text carefully, it doesn't even really hold for him, but expresses enough doubts to say, I'm not going to do it. And that is whether the president of the United States counts as an officer of the United States. She holds under 14th Amendment, Section 3, because that's what's specified: an officer of the United States who's taken an oath as an officer, etc. Now, she holds he's not. And that's been really trashed since the Colorado Secretary of State, who wants him off the ballot, says this is like a get out of jail free card for a president. Judge Ludig, calls it ludicrous. The number one point, I'll make the number 2 point, which is, it's not ludicrous. The president is not listed where other parts of the government and officials are in this list in the 14th Amendment. There are other provisions of the Constitution that likewise don't specify president by their terms, and the Supreme Court have said don't include president, on the one hand. On the other, there's a kind of, come on, are you kidding me? So you're saying that Jefferson Davis, the president of the Confederacy, could have run for and been elected president, notwithstanding this provision, after leading the Civil War? That makes no sense. Why would that be, et cetera, et cetera? That's the issue. But the bigger point is, it's just a discrete legal issue. In order to make it to the U.S. Supreme Court, and I'll get to that in a moment, but it's got to make it to the U.S. Supreme Court if it's going to prevail. A court of appeal in Colorado would have to find on that issue for the challengers. In other words, would have to find that Trump was an officer of the United States. So the fact that Wallace goes through everything and then doesn't find on this legal issue that he's an officer doesn't really amount to much, because the appellate court could find it itself, and even if she had found it, they would do what they call a de novo ruling. They would just decide it independently. On the other hand, the long thing that she did do, finding engagement, finding insurrection, and on the facts, is something that it seems to me a court of appeals can't do. Let's assume that this claim down the line somehow prevails. First, I think everybody agrees that would be because of a decision by the U.S. Supreme Court. In other words, I think what you would need to posit is that the Colorado Supreme Court finds that Trump is disqualified, and the Supreme Court steps in and reviews it for under the federal Constitution. If there wasn't this decision now that by Judge Wallace on the facts, it's basically inconceivable that the Supreme Court would go ahead and make factual determinations and findings with no evidence. The very, very best they could do is remand it all the way back down to have a trial, et cetera, et cetera. Now they actually have a factual record and generally you defer to a factual record. So without that, that's a giant step that no other court had supplied, and without it, I don't see how the Supreme Court could affirm. Now, does that mean the Supreme Court will affirm? No way, because there are other things they could say. For example, they could say that the test I just read you about what a insurrection is just too loose or would let other things in. And that's a federal constitutional issue. So that's something they could say. I thought before it was very possible they would say, as some other courts already have said, this is a political question and we can't really decide. And this gets very complicated. I'll save this for another day, but I just want to make an asterisk here that it's one thing for them to say as a federal court and separation of powers with Congress, they won't decide. It's another to reverse a Colorado Supreme Court decision if one is made, and say the Colorado Supreme Court had to back away from a political question. They have different rules about what questions they can decide or not. And normally they can decide who's on a ballot, including, for example, saying that somebody, as best they can tell, is 34, not 35, so they're off the ballot. Why have I, by the way, twice referred to the Colorado Supreme Court? Because any path to a decision actually upholding this principle, and you have to consider it quixotic, right? I mean, it has to be a sort of a long shot that the Supreme Court would, or the courts would basically decide this national nightmare we have and pull Trump from the ballot. But it has to go to the U.S. Supreme Court. I think everyone agrees with that. And it could only go to the U.S. Supreme Court if the highest court in the state had decided it, and probably would only go to the Supreme Court if the highest court in the state decides it against Trump. If they decided for Trump, the Supreme Court can just leave it alone. So if you think of what needs to happen, always has needed to happen for this claim to be recognized, it's now 90, a very giant step has been taken, because it's always had to be the case that some trial court would make this finding on the facts, and these legal issues about officer and definition of insurrection and even political question would go in a legal setting where a court of appeal can do it to the highest court in the state, and from there to the Supreme Court. So before, the table was not set for the court to in any way take up the question and decide it against Trump. And now it is, as I tweeted, perhaps a little bit too cute, but the court here makes the whole huge sundae, all the 3 flavors of ice cream and banana and nuts and whipped cream and everything, but doesn't put the cherry on top. But any court of appeal can just take the same opinion and put the cherry on top, and would have had to do it anyway, even if the trial court had done so. So this really is the prospect, the tangible prospect, which I want to say has always been something of a long shot. But the tangible prospect that this claim is actually decided against Trump has now really increased, just because an essential, not a sufficient, but a necessary large first step has now been taken by the opinion of Judge Sarah Wallace in the Colorado State Court. So in reality, this is actually a bad development for Trump. I'm not saying that it makes, that the odds are now good, that it still seems very hard to fathom in a number of ways that the U.S. Supreme Court would actually endorse throwing him off the ballot. Notice, by the way, he cannot be not on the ballot in Colorado, but in other places. That's why the Supreme Court would run in if one state it goes all the way through and they decide it. So there's still different ways it could go, but it's much more concrete, and maybe the biggest part of it, a finding on the facts of engagement and insurrection, now has been made. So the real concrete possibility of this happening is much advanced from even 4 days ago. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.